Why is there so much disquiet amongst Aboriginal people about the notion that they be Australians and that they form part of one citizenry? Is it at all conceivable that Indigenous people will one day enter into a social contract with non-Indigenous Australians as citizens of a new republic? Such questions trouble me. They lie at the root of this country's current psychological turmoil. Today, I hope to skate through some of these questions, which alternately depress me and excite me. In bleaker nights of the soul, I too have yearned to flee the madding crowd of our equivocal citizenship and disappear into a Cape York oblivion, my own humble version of the Paris option. But then there is always hope. Hope most aptly captured by Bishop Desmond Tutu when he told this club recently that we do indeed live in exhilarating times. I begin where all stories of Indigenous grievance begin, 223 years ago, when Captain James Cook first discovered, and in doing so, created us. My own people first saw Europeans when the Endeavour limped into Gungar, the site now known as Cooktown, during that now infamous voyage in 1770. This voyage was to result in the first and most preposterous ambit claim for land rights in the country's history, one that would dwarf the writs that descended like so many geometric black clouds following the High Court's decision in Mabo, and published for our interest by AMIC on full-page advertisements. Having encountered the Great Barrier Reef, Cook was compelled to spend some weeks repairing the Endeavour at Gunga, during which time he interacted with the Bubugutjin, the traditional owners there, the Guguyimir people. During his stay, Cook recorded a substantial word list of the local language, a language still spoken today. The Guguyimir grey wallaby kangaroo became the kangaroo of English. The encounter between the Bubugutjin and the crew of the Endeavour was not entirely peaceful. Incidents arose out of conflicting notions of reciprocity. The Guguyimir had offered fish to the voyagers and couldn't understand why the Europeans refused to share one of the many turtles on the deck of the Endeavour. One of the Bubugutjin leapt on board and began pushing the turtles overboard. Shots were fired and mutual antagonism ensued. Ironically, 6 months ago, a descendant of the Bubugutjin was prosecuted by the Cooktown police for the possession of a turtle in his own boat at the same Cooktown wharf, the law deeming his subsistent hunting right as illegal. The police promptly released the turtle overboard. However, despite these incidents, relative to later attitudes towards Aboriginal people, Cook's view was benign, characteristic of prevailing European notions of the noble savage. Of my people, Cook wrote in his journal, they live in tranquility, which is not disturbed by the inequality of condition. The earth and sea of their own accord furnishes them with all things necessary for life. They live in a warm and fine climate and enjoy every wholesome air, so that they have very little indeed for clothing. In short, they seem to set no value upon anything we gave them, nor would they ever part with anything of their own. This, in my opinion, argues that they think themselves provided with all of the necessaries of life. The transformation from noble savage to degenerate animal that occurred through the process of colonial settlement is illustrated by the contrasting view of the editor of Cook's journal, Captain Wharton, who almost a century later described Aboriginal people in this way. Their treachery, which is unsurpassed, is simply an outcome of their savage ideas, and in their eyes is a form of independence which resents any intrusion on their land, their wild animals, and their rights generally. In their untutored state, they therefore consider that any method of getting rid of the invader is proper, although treated by the coarser order of colonists as wild beasts to be extirpated. Those who have studied them have formed favourable opinions of their intelligence. The more savage side of their disposition being, however, so very apparent, it is not astonishing that brought into contact with white settlers, who equally consider that they have a right to settle, the Aborigines are rapidly disappearing. The change that occurred through the 19th century in Australian racial ideology reflected the increasing atrocities of frontier expansion. As the frontier became bloodier and uglier, an appropriately vicious racial ideology became necessary. Racial ideology justified the rapacious dispossession of Indigenous people. It was obviously more difficult to shoot noble savages than people who were no better than animals, who roved over the landscape like so much nuisance fauna. Professor Reynolds has clearly shown in his histories the relationship between the parcel-by-parcel process of dispossession and the changing racial ideology. This ideology, conceived in the 19th century, is this country's most fundamental and enduring legacy. The ideas generated from mid-last century and generally accepted in Australia well into the 1960s are embedded in the Australian national consciousness. It is an ideology that was given a scientific imprimatur by Darwin's theories of evolution, the great chain of being, and the notion of a hierarchy of human, physical and social evolution was vindicated and became a substantial and respected social science. They measured our skulls and exhumed our graves. Whilst Enlightenment notions of the equality of man and Christian notions that all humans are created in the image of God were inconsistent with this racial ideology, they were by no means widely accepted. Indeed, the Christian missionaries also frequently subscribed to notions of innate racial inferiority. Missionary Poland, at my Lutheran mission near Cooktown, exclaimed, "Surely in the afterlife, even black people will be beautiful." Who can deny that this legacy does not linger in the baggage of our national inheritance? Who can say that notions of racial inferiority rooted in a violent past do not still infect our national psyche? It is, after all, the baggage that your forefathers and your fathers and your mothers, your teachers and your leaders, all those who have loved you and whom you love, have given you. It is a troubling inheritance, because to deny it is to deny something of yourself, because to deny it is to come to terms with historical guilt. And guilt is something that is not necessary in order to come to terms with and to settle historical grievance. Mabo and the acknowledgement of land rights need not be about guilt, but guilt is an ingredient in this national debate, because it is the young Australians' personal difficulties in coming to terms with this remnant racial ideology and the fact that this ideology still informs our current perspectives that gives rise to a real collective guilt. It is those who refuse to recognise and acknowledge the past who are most troubled by the past. Only with acknowledgement can the debilitating baggage of our past be dispensed with and be put behind us. The law mirrored Australia's changing racial ideology, from an earlier position of colonial recognition of Aboriginal rights to land to a vehement and long-lasting denial. This denial formed the cornerstone of a dubious real property law. It was the High Court's rejection of racial discrimination under our common law that resulted in the abandonment of the false doctrine of terra nullius and which provided for the recognition of native title. The law as it stood prior to Mabo was most succinctly expressed in graffiti that I encountered in the dungeons of Sydney University Law School. Someone had called for real land rights by 88, and another responded asking, "But how can fauna own land?" This was an accurate reflection of the law. Whilst the Yirrkala plaintiffs in the Gove case might have had a complex system of social organisation, at law they were essentially animals roving over a landscape, having no recognisable proprietary interest in the soil. Justice Brennan said that our law can no longer B, nor be seen to be frozen in an age of racial discrimination. Recognition of an Indigenous inherent right to land was the natural consequence of the High Court's decision. The High Court declared that any examination of a people's social organisation to be irrelevant in determining whether people owned land. As Justice Brennan said, land is susceptible of ownership, no matter who happens to be in occupation. The rights of Australia's Indigenous peoples existed at the time of white settlement and have continued to exist ever since. It is British law which respects native title, which itself arises out of Aboriginal law. Common law native title is not novel so far as the history of British settlement is concerned. It is only novel in this country, where there has been belated recognition of native title. Mabo also means that Aboriginal law and custom is now a source of law in this country. This must be the foundation for an inherent right to self-determination of Indigenous peoples. Mabo has carved out, within the sovereignty of this country, space for the survival of a particular group's laws, customs, and culture. It has laid the basis for some future form of self-government within the life of the nation. The way the High Court has constructed native title, prohibition of racial discrimination is the best protection afforded to that title. Overarching legislative and constitutional protection for native title is therefore critical, because it is extremely vulnerable and can be extinguished by valid acts of the Crown. We felt at the outset of our campaign that the High Court's decision should have meant two things. Firstly, recognition of bare legal rights, which would only address the needs of 5 to 10% of Australia's Indigenous people. But secondly, half of the 220-page decision is a survey of Australian history, of the parcel-by-parcel extinguishment and the racist doctrine that meant Aboriginal rights were obscured for the past 204 years. This gave rise to a need to implement, to use Justice Dawson's phrase, a new policy for the 90% who would not be able to enjoy any remnant rights under the court's decision. This was the lesson our highest institution had laid forth for all of its citizens. Instead, we had the debate about how we can contain and neutralise the legal and political power that Mabo has afforded us. That's why in the middle of discussions over the legislation, there came a very clear call for the rolling back of the Racial Discrimination Act, because state governments wanted to selectively control, acquire and extinguish native title and the rights afforded by the High Court. In our campaign, we focused on the RDA, not because we were trying to extend the court's decision, but to preserve the few titles that survived to be enjoyed. We felt there was a clear onus for reparation for the 90% who wouldn't be able to avail themselves of bare legal rights. Instead, we found ourselves defending the integrity of the legal rights of the 10%. It was not an offensive campaign that we waged, it was defensive. It is ironic that our major success should be seen as preservation of the protection of our people from racial discrimination. I was amazed at the import of the rolling back of the RDA was lost on most people at the outset. The politicians, even those who were very much on our side, were stared down. They insisted that it was a technical necessity, and nobody thought, after 18 years of abiding by the International Convention, that this technical suspension was anything of consequence. The battle for maintaining the integrity of the RDA had to be waged at home first. Our approach was that the onus for obedience to international human rights falls upon ordinary Australians. If the politicians abandon us, then it is a matter of seeing how willing and how determined we are to make sure that there is no ultimate abandonment. Like my colleagues, I was extremely heartened by the groundswell of public support for not rolling back that act. The Mabo issue, unlike any other, has been about policy, law, and most importantly about presentation. It's been a game of mirrors. All the players have been building these mirrors that expand or limit the impact of the decision according to political agendas. A great deal was made of the credibility of ambit claims of the different players. The miners and farmers talked up the claims to land, in Western New South Wales as though they were serious propositions, when any one of the army of lawyers they employed could have told them that that was not necessarily the case. They, however, deliberately beat up that campaign so that in those few cases where rights survive, they could create the necessary political furore to ensure those few rights are neutralised. In my own assessment, the stance of political leaders is absolutely critical to unpacking the psychological baggage we have carried with us from last century. The Prime Minister's approach has always been to portray Mabo in a positive light. Sure, it has caused some economic and social confusion, but this is positive confusion. This is the confusion that the country has to have and has to go through. It's not dogs and high water and cats raining down from hell, as our opponents would paint it. The Prime Minister has been exemplary in his approach. By adopting a defensive position, some of the premiers have wasted an opportunity for educating themselves and the country as a whole about Aboriginal people. It would have been much easier had the simple story of justice been spelled out to people. I have been critical of the Queensland Premier because I felt that his response from day one was negative. Perhaps he was trying to hose down the public and the Chamber of Mines, but he succeeded in reinvigorating the very racist doctrine about land ownership that the High Court had just tossed out. Perhaps he was trying to calm people down, but I don't think that was the proper strategy. Governments should not adopt a defensive position in relation to Mabo, given that it is a tool of limited applicability and a tool that is 204 years late in the coming. I've said something about the other players, so I should say something about our team. There's been a lot of questioning, as always, about how representative we are of Indigenous views. In all our dealings with the federal government, the Joint Land Councils have been at pains to say that we can only speak for ourselves. Our constituents happen to be in the areas where Mabo is really going to matter as a question of bare legal right. In the Kimberleys, Cape York and the desert areas, native title is still a viable proposition at law. In those areas, people have been most anxious to say that you can't achieve the most perfect settlement all at once. In Cape York, I don't want to be in the position of recovering land that's under sugarcane plantations and mining leases. Our chance to recover lost rights must be grasped now, because as time goes on, the struggle gets harder. Because of our defensive position, we have to have this legislation. The legislation is necessary for the protection of native title. Reconciliation is therefore going to be piecemeal. The land title legislation is but the first step. The current discussion about land acquisition, social justice, and participation in the economy is very important. People need a land base. The third step must be emotional reconciliation. And this will be very hard for our people. They bear deep emotional scars. With reconciliation, this country has an opportunity to construct a relationship with its Indigenous people so that their right to be equal and different is represented in its constitutional structure. Australia may be late in coming to terms with the existence of native title, but it's in a position almost unparalleled in the world to give effect to reconciliation of historical grievance. There's deep apprehension about which way the world will go. On the one hand, there is optimism, the Berlin Wall, the collapse of the Soviet monolith, and South Africa. But on the other hand, there's evidence in other parts of the world where severe fracturing is occurring on ethnic lines. Despite all this, Australia is best poised to accommodate ethnic diversity within a single nation and to settle historical grievance, even if those grievances will never be forgotten. We should never underestimate the use and the power of law and institutions in all of this. As long as people are subject to discriminatory institutions, there are always going to be grievances. The High Court has taken the most fundamental first step towards reconciliation, but more political steps need to be taken. The most basic truth following Mabo is that the recognition of land rights is now a matter of recognising rights that are inherent at law. It involves respect for property ownership, no matter who the owner may be, and no matter who the beneficiaries of that ownership might be. Land rights in Australia can no longer be about largesse, about moral obligation, about sympathy, empathy, or guilt, or about the Aboriginal condition. It is about recognition and restoration of legal right. The Crown can no longer presume to grant land to Aboriginal people and to create land rights. It can now only recognise and restore. To the hoary notion that land rights will result in the creation of a black state, Mr. Justice Brennan responded in Gehadi versus Brown as follows: "The difference between land rights and apartheid is the difference between a home and a prison." Frank Brennan echoed this wisdom recently in his book, Finding Common Ground. Society has a responsibility not only to recognise land rights of remote communities, but also to fulfil the land needs of urban and fringe-dwelling Aborigines. The plight of the poor dispossessed white person does not excuse us from considering that of the Aborigine. It is merely suggestive of the need for more widespread social change than what is being contemplated under the banner of Aboriginal land rights. The most comprehensive answer to the notion that land rights is somehow discriminatory is to be found in the papal message to Australians at Alice Springs in 1986, with which I will close. Let it not be said that the fair and equitable recognition of Aboriginal rights to land is discrimination. To call for the acknowledgement of the land rights of people who have never surrendered those rights is not discrimination. Certainly what has been done cannot now be undone. But what can be done now to remedy the deeds of yesterday must not be put off until tomorrow. Firstly, to answer the second part of your question, the federal legislation will provide a mechanism for the conversion of Aboriginal-owned pastoral leases into native title. Now, I anticipate as a result of that facility that Aboriginal groups will be primarily pursuing conversion claims in relation to pastoral leases that they currently own or will acquire in the future. As to the question of whether native title survives with all forms of other title as a coexistent title, that is a matter that is unresolved by the High Court and may well be the subject of future litigation. However, that is a matter of people pursuing their rights at common law and not being precluded from arguing that under the umbrella of the rights that are owned by non-Aboriginal people, there may still be existing Aboriginal rights as well, coexisting ones. The question was deliberately rhetorical, given my own equivocal position about the answer to that question. I think all Aboriginal people that I've encountered, as desperate as they might feel about the need for their incorporation into the general Australian community, the conditions are such that any incorporation into a national citizenry is on the basis of them compromising their rights and not being afforded a full and respected position in the constitutional structure of this country. We are not parties to this national federation. We never were back in 1900, and we never voted in 1967 to join the national citizenry. So to this stage, we stand outside of the national polity. And obviously, given the alienation and the deep emotional scars that Aboriginal people still have about their historical treatment and their current treatment, the question of whether people will one day be reconciled to a single nation under a republic still remains to be answered. What was the second question? Well, I think the notion that Aboriginal people's self-determination must result in a form of self-government is a notion that's well accepted in other jurisdictions. In Canada and in other Indigenous areas across the planet, there's greater recognition of the rights to self-government of Indigenous peoples. Now, some of those models do not involve the usurpation of the nation state, but they can be accommodated within the confines of a nation state. And we already have an example of that in Australia with the Norfolk Island self-government model. And the fact that Aboriginal people are the beneficiaries of the only right to have our laws recognised and respected within our Australian legal system surely lays the basis for our right to carve out a self-determination domain. I think we had reached the stage by Black Friday that if the federal government had not clawed back a position on our behalf from the states and industry, then there could have been no equitable settlement of the Mabo decision. What had happened was, as I said, during a very defensive campaign, we had found ourselves in the position where all of the fat had been cut off of our proposals and we were left with the bare skeleton of the High Court's decision, and even that was to be soon ground to dust. We found ourselves in a position where we could not take what the government was offering at that stage. And the political imperative of seeking some kind of national consensus on Mabo, getting the states on board, had resulted in us retreating back over the cliff face. And what occurred in the following 2 weeks was a grabbing back of our position by the federal government on our behalf. And to such an extent, and particularly the preservation of the Racial Discrimination Act, it meant that a solution was crafted that would meet our minimal requirements. I happen to work for an organisation that's infiltrated by former Liberal politicians who are very good advocates for our cause in Cape York. But that particular Liberal politician comes from a Liberal party of old, a party that respected rights to property, that vehemently denied racial discrimination, and respected the rule of law. What we have now is a Liberal Party that's struggling even to recognise what is patently the High Court's decision. And not only to give recognition to the decision, but to not just recognise it in order to annihilate it. So my concern is that the opposition have in the past played a very important role in Australian society. The implementation of the Northern Territory Land Rights Act fell upon the Fraser government. The establishment of the Aboriginal Development Commission was a Fraser government initiative put in place. And the Liberal Party have a proud record in Aboriginal statutory land rights across the country. But it is a Liberal Party that is not mirrored in the current rabble inhabiting the House at the moment. I mean, I speak with very limited experience, and I must say that the faith and hope that my colleagues exhibited, people who've gone through much more disappointing struggles for the recognition of rights in the past, particularly during the 1970s and the 80s, particularly over in Western Australia, I've got to say that their willingness to engage in another round of trying to secure something for their people was a source of inspiration for me. I must say, after my 1991 experience, I was devastated personally that no matter how reasonable we tried to couch our propositions and our arguments, at the end of the day, if there was no good political will, we were never going to get anything. And that's the difference between the process that I've been involved in the past, or at least that one process that I was involved in, and what's happening at the moment. Fundamentally, there was goodwill in the leadership of the country for a proper recognition of the High Court's decision. Obviously, putting that goodwill into black letter law has been a very difficult process. And we've fought a defensive campaign to ensure that what results at the end of the day is decent law. But I've got to say that our political position in this country is so marginal that at the end of the day, if there is no good political will, we will inevitably lose. I'm going to sound like a liar when I respond to that last question by saying no, because that's what they all say. But but definitely not. In relation to the people perhaps departing from the agreement, I think necessarily, given the complexity of this bill and the complexity of the law that will be contained in this bill, there's always going to be nervousness and some disquiet as to people's understanding of what has been agreed and whether it's reflected in the final result. But I don't think, from our point of view, we discern any substantial departure from the position we were at 4 weeks ago. I think, though, that the Greens are quite rightly concerned that the views of Aboriginal people right across the country need to be taken on board, and they need to represent those views in the Senate. And obviously that's a role that myself and other Aboriginal organisations encourage them to perform. But as to who and when we make the judgment that what we have achieved is sufficient, that it honours the High Court's decision and is going to result in the recognition of native title rights for people who have those rights, that's a decision that needs to be made cooperatively, I think, over the next few weeks. And people need to get realistic about what is achievable, but we also must be careful that the agreements that we have reached are actually reflected in the final result. I think I'm amazed at the difference between the generation that my nephews and nieces are growing up with in schools and that which I went through. There's a totally huge difference between their attitude towards Aboriginal people. There's a vast revolution taking place amongst younger Australians about the importance of recognising principles of racial equality and respecting people of ethnically different backgrounds. I witness that amongst young kids that I've encountered. And it's a big change that's happened over a period of 10 years. And I really think that it's going to produce an Australia that's vastly different from the Australia that our parents presided over. But I think it's going to be a slow process, and critical to that process is restructuring and reconstruction of our national institutions on the basis of racial equality and respect. You cannot have on-the-ground change without changes in the structure. And big changes in the structure, a radical reconstruction based on the proper incorporation of Aboriginal people within the legal and political system that recognises their right to be different as well as equal. Until that takes place, you won't achieve the real on-the-ground revolution that we're starting to pick up on at the moment. Well, I'd like to live in a world where everything's goodness and light and roses and respect, but the fact of the matter is that we were very close to losing all of our legal rights purely on the basis that our rights had become a political issue. And in order to respond to that situation, Aboriginal people have necessarily had to become political. What Geoffrey Blaney is saying, what Ian McLaughlin is saying, are matters that really have consequence for us. They're saying things about us and about our rights that go to the question of whether we should be humans that ought to be respected as having rights. They are returning to a racist debate that occupied Australia in the 19th century. And for Aboriginal people to naively sit back and think that, everybody's finally going to do the right thing by us is to live in a world of unreality. And despite the dangers in engaging in the cut and thrust, I think at the end of the day, we can't be expected to remain impotent whilst the likes of Geoffrey Blaney Richard Court and Ian McLaughlin talk about annihilating us. It's been carefully constructed for one purpose. That is, it sought out every native title in the state of Western Australia for the purposes of extinguishment. So in that sense, it has been very carefully constructed legislation. However, we feel confident that what has been done by the Western Australian government is not lawful, and we would expect that Commonwealth legislation would render that act unlawful by its own operation. What we have from the federal government is a commitment that its legislation will provide umbrella protection for any native title right across the continent, and we would expect that that protection include an invalidation of anything that any state premier might do to the contrary. Even as I disappear into obscurity in Cape York at the end of this campaign, I think that one thing that is now a necessary consequence of what we've gone through after Mabo is that Aboriginal affairs and the rights of Indigenous people in this country is a mainstream, upfront, unavoidable, can't put in the drawer political issue. And Aboriginal people will demand and expect a participation in the economic life of this country till the end of this decade, and in the political structures of this country from now on. I think Mabo and the debate that ensued has wrought a lasting change to Aboriginal participation in national life. So I think that there will be those who come behind us who will have further dealings with the Prime Minister and the federal government, with a view, I think, to using the opportunity of the last 7 years of this decade to achieving that which we have failed to achieve in the past 204 years, and that is a proper respect for the position of Indigenous people on their own country. I think on that last question, there's going to be obviously constitutional challenges to the to the court government's attempt to wholesale extinguishment. There is an assumption that the payment of compensation for that extinguishment will validate whatever the court government has done under its laws, but our legal opinion is to the effect that that is insufficient. The court government has not passed a law to radically extinguish the property rights of no other class of race in Western Australia, but it has done that in relation to the Aboriginal people. And unfortunately, what will happen is that there will be challenges to the court government's legislation, which will drag on in the courts, and there will be challenges to whatever remedial action the federal government might take. And I think that's an unfortunate situation. But it has to be lain, that situation has to be lain at the feet of Richard Court and his government. As to what happened in the early mornings, I think Philip and members of the negotiating team are competing with each other to write the definitive account. But I think the big change that occurred was the Prime Minister grasped the agenda very firmly and took control of the process at a very detailed and personal level. And it was that action which finally secured the result that's been achieved. That's my interpretation of what's happened. Details on what the federal government will do in relation to social justice, apart from the establishment of a land acquisition fund, are still to be discussed. I think we're at a very early stage of working out what a necessary social justice package should involve. I think that because the social justice package will affect the 90% of Indigenous Australia who've been deprived of their native title rights. I think that the process of consultation and discussion about what that package should involve necessarily should be comprehensive, and that opportunity for involvement by those groups who weren't at the front line of discussions about native title, that opportunity should be made available and should not be avoided. I think the fact of the matter is that most of the native titles in this country have been extinguished. They have been taken away over the past 204 years. We are talking about remnant rights. And the question which the High Court has posed, and which is answered by the federal government's suggestions about a social justice package, is what reparation is going to be made to those people who have lost rights. If there's anything about which people proclaim consensus right across the political spectrum, is the need to address the disastrous health, education and social condition of Aboriginal communities. And that is a very important endeavour to which even the National Party will subscribe. But I think that hand in hand with that kind of improvement must come recognition of fundamental human rights and rights to land. I think the better social conditions identified by the Royal Commission into Aboriginal Deaths in Custody, the better social conditions were identified in those areas of Australia where people had been restored to their traditional lands and had access to some kind of land base. There is too little understanding and appreciation of the deep psychological damage that has been done to Aboriginal people by being forced off their traditional lands. These are people which in my language we call wuntur. They're like zombies. They're people who've lost something very, very important to them. And if you're going to have a period of recovery for those people, where people are going to put their communities together, you're not just going to do that by education and health programs. You're going to have to do that by restoring their relationship with traditional land. I think if Fred Chaney were the leader of the present Liberal Party, that bipartisan support for the response to Mabo might have been forthcoming. I think it's tragic that a substantial section of the Australian community, by virtue of the prejudice of their political leaders, are not going to make that psychological leap towards recognising that Aboriginal people should be afforded dignified recognition of their inherent land rights. Without that meaning, we have to pack up and go back to England. There's a certain maturity that comes with accepting that Aboriginal land rights can stand alongside of mature economic development and prosperity for the whole country. There is something of a mature step to be taken to accept that those two propositions can stand side by side. And I think if we had a nation in which we could restore some of the consensus that we saw in Australia when the Northern Territory Land Rights Act was put into place, if we can secure an Australia that stayed on that keel, we might get somewhere. But as long as people are donning hoods and wielding flaming crosses when formulating their policy on Mabo, I don't think we're going to achieve that.